Hello and welcome to Verdictum. I am Ramakrishna Rana and today we are going to explain to you a few interesting judgments of this week from the Supreme Court.
This is Kanchan, and the first case we have for you is Madhyam Broadcasting Limited versus Union of India and others. In this case, it was held by the Supreme Court that the state cannot claim absolute immunity from disclosure of material by merely claiming that they are related to national security. Further, deprecating the practice of filing sealed cover report in court, the Supreme Court held that it was a violation of principle of natural justice as it curbed the right to fair and reasonable proceedings. The bench of Chief Justice D.Y. Chandrachud and Justice Hima Kohli in the case where Ministry of Information and Broadcasting had refused to renew the license of Malayalam news channel on the ground of security clearance held that an independent press is vital for robust functioning of a democratic republic and that mere involvement of issues concerning national security would not preclude the state's duty to act fairly. The court, on the other aspect, condemned the practice of sealed covers and held that the sealed cover procedure restricts the core principle of natural justice and violates Article 21 of the Constitution.
The second case we have is National Insurance Company Limited versus Harsolia Motors and others. The issue in this case was, do the commercial entities insured qualify as a consumer under the Consumer Protection Act, or do they have the only legal remedy of approaching the commercial court under the Commercial Courts Act against the breach of insurance of policy? The Supreme Court of India in this judgment clarified that any activity or transaction insured which is for non-commercial purpose and not for generating profits, the entity insured will fall under the definition of consumer under Section 21D of the Consumer Protection Act. The bench of Justice Ajay Rastogi and Justice C.T. Ravikumar held that to determine whether the dispute filed by a commercial entity would qualify as a consumer dispute or a commercial dispute, then the twofold classification are the commercial purpose and non-commercial purpose. The court, by quoting several examples, stated that if the goods are purchased for resale or for the commercial purpose, then such consumer would be excluded from the coverage of the Act. And as against this, if the same manufacturer purchases a refrigerator, television or an air conditioner for his use at his residence or even for his office has no direct or indirect nexus to generate profits, it cannot be held to be for commercial purpose, and for aforesaid reasons, he is qualified to approach the Consumer Forum under the Act. In this case, the State Consumer Redressal Commission had dismissed as non-maintainable the complaints on the finding that the business from the premises to earn profits fall under the term commercial code and not under Consumer Protection Act.
The third case we have is Mansarovar Commercial Private Limited versus Commissioner of Income Tax Delhi, where the court held that domicile or registration of company is irrelevant under the Income Tax Act. It further held that to evaluate whether the business will come under the Income Tax Act, the head or the seat or the relating powers of the affairs of the company and the control and the management must be shown. The bench of Justice M.R. Shah and Justice B.V. Nagaratna stated that the domicile or the registration of the company is not at all relevant and what must be shown is not merely theoretical control and power but de facto control and power. The determinate test is where the sole right to manage and control of the company lies. The court found out that assessees with malified intention and to wriggle out the clutches of the Income Tax Act by evading from the payment of tax came out with a case that they had earned a lot of income within Sikkim which has not been established and proved.
The fourth case we have for you is the Director, KPTCL and others versus CP Mundimani and others. Here, the issue arised was that can retiring the next day of earning your annual increment disentitle you with the benefit of the same? Clarifying the anomaly, the Supreme Court held that the government employees cannot be denied the annual increment merely because they were to retire on the very next day of the earning the increment. The bench of Justice M.R. Shah and Justice C.T. Ravikumar observed that the moment a government servant has rendered service for a specified period with good conduct in a time scale, he is entitled to the annual increment, and it can be said that he has earned the annual increment for rendering the specified period of service with good conduct. In the case, the Karnataka Power Transmission Corporation Limited had denied annual increment to employees on the ground that they had retired the next day. The court held that if such situation is accepted, then it would tantamount to denying a government servant the annual increment which he had earned for the services he had rendered over a year, subject to his good behavior. The entitlement to receive increment therefore crystallized when the government servant completed the requisite length of the service with good conduct and became payable on the succeeding day. Thank you and keep watching Verdictum, the dictum of truth. Subscribe to our channel and download the Verdictum app on iOS and Android to keep yourself updated with the legal news.